Supplementary list for pronouncement of judgment. Item 29.
During the above discussion, the interim judgment passed by the single judge is hereby set aside. The appointment of the respondent number 4 herein as caretaker chairman of the ADC approved by the order dated 27/3/2023 is also set aside. However, the relief claimed by the appellant for issuing direction to the respondent state to appoint him as caretaker chairman of the ADC approved is declined. The intra-court appeal is disposed of with above observations and directions.
May I please your lordship? In so far as item number 6 is concerned, I am for the appellant. We have filed an interrogatory application to substitute respondent number 10 and 11, my lord.
In which matter?
6, item number 6.
Six.
This matter will come up along with the IA.
The IA.
IA we have filed. I have the serial number, my lord.
Legal and consent for the appellant has submitted that an application is prepared for including for substituting
Substitute.
respondent number
10 and 11.
10 and 11.
11.
The office is directed to produce the place the same on record list after a week.
On the
Lordship, next week a date may be fixed, Lordship.
Whatever the date. Date next week, no, what about?
may I submit the mention memo, lordship. Submit the mention memo for IA.
Much obliged, Lordship.
You please give the.
Obliged.
May I please your lordship? May I please your lordship? With the consent from the opposite party, I beg to mention item number 4 for adjournment, your lordship, as senior counsel is not in good health and out of station.
Complete on respondent number. Urgent.
A date may be given, your lordship.
Last week, March, April, May.
For orders, item 1.
Please, your lordship. Lordship, we require some more time to take steps upon the sole respondent because he is not available in the present address. We are unable to collect the new address of the respondent.
On concept, seeks some more time to furnish fresh correct address, / correct address of the sole respondent. Just after 3 weeks.
Highly obliged.
Item 2.
Wait with your lordship. Representing Arunachal Pradesh, in this case, after the order passed on the last occasion, we have preferred an application, for extension of the timeline granted for construction of the road in the main PIL. So may I pray to them that this matter along be listed along with that PIL and the IA that we have already filed.
Earlier,
My lord, actually 2 years timeline was granted, my lord,
by this court,
by this court, my lord, yes.
fine.
And my lord, the work progress beyond that deadline, there was no application for extension, my lord.
That time limit expired
On 17, my lord.
this 17.
2017.
2017.
Yes, my lord. The matter was disposed of, no?
Still
Yes.
you are seeking more time.
No, my lord, our effort was from before, my lord. We elongated application, lordship. I will produce our correspondence and everything. There was no, my lord, at any stage, my lord, no latches on the part of the state.
No latches and still the road has not been constructed.
61%, my lord, 2 months time they are seeking, my lord. Your lordship will see the construction is seasonal, my lord.
Within 2 months.
Yes, ma'am.
complete
Yes,
the road.
yes, ma'am. In the application, I have prayed for 3 months, my lord. 1 month is abandoned portion, but they have sought 2 months time. By April, they say they'll finish it. So let both these matters be listed together, my lord.
Then concept of the applicant has submitted that in the main PIL. Then concept of the respondent has submitted that in the main PIL. The application is filed on behalf of the respondent seeking
Ma'am.
extension for completion of the project. Full stop. In view of the above, let this contempt petition be listed along with the
PIL 101, ma'am.
PIL number
101 of 2013, ma'am.
101 of 2013,
Disposed of on 18/9/2014.
disposed of on 18/1/2019,
2014, ma'am.
2014,
Ma'am.
on 10th of April.
Ma'am. Much obliged.
Item 3.
Mayor, please, your lordship. Lordship, service is not complete in this matter, lordship.
You have not taken any steps.
Lordship, we could not take step, lordship. Further, some time may be given, lordship, to take dusty service, lordship.
Last time on 3rd of January, time was granted.
Lordship, that service was not completed, lordship, because some other person had received.
You have not taken any steps.
Lordship, some time may be given, lordship.
In concept of the apply, there's some more time to take fresh steps for service of notice upon the respondent by justice service through registry. The justice service time paid for is granted just after 2 weeks.
Obliged.
Item 5.
Mayor, please, your lordship. Your lordship, as per the last order dated 1/3/2024, lordship, the service in respect of the respondent number 4 and 5 is completed. A report has been given by the deputy registrar.
What about 6?
Six, my lord, has already been, they have already.
4 and 5 are already as per the report of the Lauzima court. Service of notice upon the respondent number 4 and 5 is complete. This matter for admission
In the first week of May, also.
in the first week of May.
Highly obliged. Obliged, lordship.
Item 7.
Please, Lordship. Lordship, further time may be granted to file an affidavit, Lordship.
In concept of the respondent number 1 to 4 face some more time to file. Counter to the writ petition, time paid for is granted less than 4 weeks.
You are appearing for 1 to 4.
1, 2, 3, and 4, Lordship.
I am for respondent number 5. Item number 8.
From present, just after 4 weeks.
Item 9.
But lordship, this retable is delayed by 8 days. So at this stage, notice may go.
Respondent number 1 notice has not been served. Service not complete on respondent number 1.
This is the first day, no?
First day today.
This is the first day.
This is the first day.
Yes, ma'am.
No, the notice has already been issued on 24th of January.
Only.
Notice to the contempt petition has already been issued.
Probably
Bacha Babu Singh.
yes,
Yes, notices have already been issued on 24/1. You are not aware. Your presence is there, Mr. Das Gupta. Forgot.
so that's all right.
Notice has been issued, you have taken steps also. ID card is available. Sir is available.
Await return of notice of sole respondents. Sole respondent for 2 more weeks.
Right.
Item 10,
May it please your lordship, my lord, respondent appellant, my appointment has been set aside by the London single judge, delay of 31 days.
Why?
My lord, my wife was, the petitioner's wife was pregnant, and my lord, for that reason,
Issue notice of application under section 5, the limitation to the respondents. Steps be taken.
1 to 7 official.
1 to
I for respondent number 6.
And Mr. Majumdar, you are appearing for other.
All the others. Yes.
1 to 5. Issue notice, then
4-5.
4/5, and notices to issue to them. Acha, this
1 to 3 and 8.
1 to 3. Issue notice of the year. Mr. Majumdar put in appearance on behalf of the respondent number 4, 5, and 6.
4, 5 and 4, 5, 7 and 8.
4, 5, 7, and 8.
Eight only one.
And so is appearing on behalf of the respondent number 5. Let notices issued to the respondent number 1, 2, and 3. Steps be taken within a period of 1 week. Notices are returnable. Notices be made returnable after 3 weeks.
You are appearing for the principal or?
Malad, for the 8, Malad, that is a mistake, Malad. It has to go by registered agent.
2, 1, 2, 3, and 8 notices be issued. Mr. Majumdar is not applying.
item 11,
may I please your lordship.
4, 5 and 7. 6.
There is an application for condition of delay of 17 days in filing the return.
Yes,
My lord, I am for respondent number 1, my lord. My lord, I may be allowed 2 weeks time to file the objection, my lord, in the IA for condonation of delay, my lord.
2, 3, you are only for
1, my lord.
1,
Yes, my lord, private respondent,
and other are the fisheries department.
my lord.
Do you have a copy of contempt? You are appearing on behalf of whom?
Respondent 3, he's on behalf of respondent number 2, number 3.
3 and 7, 3 and 7.
3 and 7. Yes.
5 and 6 and both the RB Bora for 4. RB Bora. He is also accepting notice for respondent.
Yeah, what do you want to say?
My lord, they have, my lord, in the condonation petition, my lord, they have stated they don't, they came to know after, my lord, 3rd week of January 2024, my lord, whereas the advocates of the respondent number appellants, my lord, was present on that day. But after, yes, my lord.
Hardly matters.
My lord, they have misleaded, my lord. The advocate was
my
present, my
lords.
lord, they don't know, my lord.
Then hear it on minutes. Why to? Otherwise also even after this is your only objection.
My lord.
The matter comes upon for consideration of the parties are represented to their respective concerns. The matter comes upon for consideration of the IA number so and so with a prayer to condone the delay of 31 days in filing the present connected appeal. Learned counsel appearing for the respondent number 1 as opposed the application.
Page 6, para 4, my lord, A.
Having heard the learned counsel for the parties, and after going through the contents of the IA number so and so, we deem it appropriate to allow the same. Hence, if the IA is allowed, delay of 31 days in filing the connected appeal.
17 days, Lordship, in this case.
17 days.
17 days.
Okay, 17 days in filing the present IA is condoned. Filing the writ appeal is condoned. Registry is directed to register the connected appeal and list before this court for admission. After 3 weeks.
Deeply obliged.
Item 12.
Have Lordship. Lordship, I for consideration of delay Lordship, 212 days Lordship. 212 days delay Lordship.
Great delay.
Yes, Lordship.
How you have explained it? How you have explained?
So
it?
I said, para number 4 Lordship, the regarding Lordship, the financial hardship Lordship. So since last,
Financial hardship.
yes, Lordship, since last 9 years.
He is facing financial hardship and then also he has engaged you as a counsel.
Lordship, whatever here in this case, Lordship. So since last 10 years, Lordship, my salary hasn't been received, Lordship, as a security guard, Lordship, under the limestone mining project, Lordship. So, Lordship, the honorable court is directed.
Notice of the IA number so and so, returnable, requisites be filed within a.
Therefore, my lord, the applicant was shocked after the perusal of the impugned judgment dated among the counsel for the applicant did not inform in respect of the impugned judgment.
And also, Lordship,
This statement is a direct attack to
You are
the
appealing
lawyers.
to
my
whom?
lord. This statement is a direct attack to the lawyers.
Which respondent?
The para 4, my lord, first line.
You are appearing for whom?
I'm for the mine department, my lord. Mining,
mine and minerals, Lordship.
mines and minerals. 1, 2. 1 and 2, my lord.
1 and 2, what about this Director Mineral Development Corporation?
That is a corporation, my lord.
Limestone.
It will notice will go, my lord.
Okay. Why, you are referring to para 4 of the application?
Yes, Lordship, IA Lordship.
So. Where is, क्या लिखा है इसमें, what he has alleged against the lawyer?
Only says that the applicant was shocked after the perusal of the impugned judgment dated 3/6 for the counsel for the applicant did not inform in respect of the impugned judgment. My lord, it is a duty.
Allegation is simply stated a fact.
My lord,
Okay, he has not informed me. That's
Yes,
all.
Lordship.
it is a duty of the petitioner also to pursue the case, my lord, what is what.
My friend, learned counsel, unnecessary is this very. The delay
The matter comes upon for consideration of the IA with a prayer to condone the delay of 212 days in filing the connected appeal. Mr. So and so. Put in appearance on behalf of the respondent number 1 and 2. Let notice be issued to the respondent number 3 to 7. The return level requisites be filed within a period of 1 week. Notices may be made returnable after 4 weeks.
Master.
1, 4 and 5, my lord.
1, 4 and 5.
Master.
For admission, item 13.
It is an appeal by the department against the order dated 4/8/2023. But here, suggested some substance violation of law. Here, Lordship, the respondent is a manufacturer of syringe. Lordship.
But the tribunal has lands on the decision of the Supreme Court.
No, Lordship, there are two questions. One, whether they are assembling the syringe in Guwahati, Lordship, in Guwahati unit. And they are
We
providing
observed
the,
that Reliance judgment delivered in the Honorable Supreme Court case of Veneer so and so, which is
Lordship,
widely applicable in this.
Lordship, in 2015, Supreme Court has stated what is the manufacturing process, Lordship? In 2015, Lordship, I find it very this. In 2015,
Well, this judgment is overruled.
which one, Lordship? Yes,
They-
Lordship, that is an overrule.
Overruled.
Yes, Lordship.
By which judgment?
Lordship, the referred by the CSAT, Lordship.
This CSET has referred this 1997 one ELT.
Lordship,
J19 SC.
judgment relied by the revenue before the CSAT, that is an overrule, Lordship.
This judgment, the
That is,
tribunal has read
no,
upon it is,
that is in force, Lordship.
that is in force.
Yes, Lordship.
Then
Lordship, what happened here, interpretation of clause 5 of the injunction notification, which says that what is the manufacturing process? Here, Lordship, the question is,
being subsidiary now, they've been there. It's about exemption. Contracts. The copy of the judgment, do you have that copy of judgment?
Lordship may fix day after tomorrow, on Monday, Lordship. I'll-
27th March.
No.
Item 14.
The writ appeal by the state against the order dated 29/4/2022, passed in WBC 6284 of 2021, my lord. We were directed to consider the candidature of the writ petitioner for selection and appointment as a teacher in the Department of School Education, my lord. With the-
Only consideration is there.
My lord.
Election of consideration is there only.
My lord, the honorable, the learned single judge has, my lord, allowed the writ petition on the ground that the clause which related to the relaxation of age was superseded by another notification. But the stand of the department is when the candidature of the petitioner was rejected because she did not fulfill the age criteria, that was in September 2021, September or October 2021. Thereafter, my lord, after other writ petitions were filed and after the entire selection process was over in the month of February 2021, the writ petitioner approached in September 2021, my lord, when other writ petitions which were filed in time had been allowed. After the entire selection process has been over, my lord, without making the selected candidates a party,
That
this writ petition has been.
subsequent notification was retrospective in nature.
My lord, to the understanding of the department, no, my lord.
To the understanding.
My
of
lord,
the
yes, my lord. No, learned single justice said that it is retrospective, but my lord, it was not a clarificatory notification. It simply erased one condition which was already there in the notification, which did not have any ambiguity in it. The condition in the notification was that only those candidates who had acquired the educational qualifications prior to attaining the age of 38 years would be entitled to an age relaxation. Thereafter, the selection process started. Appointments were made. Selection process ended. It is thereafter the second notification came where the government said that we are deleting that particular condition in the office memorandum. That you are required to take the qualifications prior to the attaining the age of 38 years. That part we are only deleting.
Where is the first notification? and
My
the
lord, lordship,
subsequent-
find that
64, page 64.
page
The subsequent clarification.
127.
The first
64,
first notification,
64.
64.
64.
60.
Lordship will find at clause 3.
Just a minute. Which when they also repeated the things which are typically are the dates of this poem. Where is the subsequent notification?
Page 129.
72. 72.
129 difficulty. 129 difficulty.
Yeah, like it was. Take it out. Government service.
And the rule says what?
The rule says that we will follow the office memorandums given by the government of Assam. Government of Assam office memorandum lordship has seen on the other part.
Rule specifically
Rule
says
is specific that whatever the government prescribes is what the department follows. We do not lay down any upper or lower regime. In fact, my lord, at page 139, learned single judges refer to the case of Gelasram Sahu to.
the advertisement was issued prior to issuance of the second September
Yes.
2020.
My lord, the first notification came in September 2nd. Advertisement came on 11th of September. Entire selection process along with appointment orders was finished on 5th of February 2021. And the clarification, as it is said to be now, came on the 20th of February after the process was over. And petitioner approached the court in September 2021.
That qualification that was prior to the selection that we had to the recruitment process. Prior to the recruitment process, prior to the recruitment process, prior to the selection. 41. 41. This is not the repeat of 29, 50,000. Qualification prior to recruitment. She was debarred on what ground?
My lord, she did not fulfill the age criteria. She did not acquire her educational qualification prior to completing the age of 38 years. So on that ground, she was rejected in the month of December itself. Entire recruitment process ended in February 2021. She did not object to it at any point of time till the process was completed. Then the new notification came saying that we are deleting it. She did not come to the court. She came in September, that is 7 months after the entire process was over. And now, my lord, she has, although she has named a few candidates, that these are the candidates who scored below me. None of the candidates are parties in this repetition. So we'll have to throw out someone to bring her in. And they are not a party before they were not a party before the honorable court, my lord. Had she come on time, my lord, other petitioners had come, they were allowed. Those who came immediately on the rejection, we have allowed.
Yes.
She came much after. After those petitions were allowed, she took a chance. Fencita.
My lord, seeing the second notification thereafter, which makes it clear that if I obtain an education qualification, after that 38 years prior to that, the first notification, I'm eligible. And the similar ground at page 109, there was another petition which was allowed, and at page 120, the observation at para 40 and 41 was there. My lord, they have not challenged that. That has attained the final rating.
Maybe, but.
And thereafter,
here-
my lord,
Here the case is that after this selection is over,
my lord,
if you approach the court after 7 months.
my lord, and
the-
regarding
And the court has given a direction that to adjust you. while
To
placing
consider
you in
my
the
case.
Merit list. While placing in the appropriate place at merit list,
my lord,
they have to approve somebody else.
my lord, as regards making party all the selected candidates, which subject to all my corrections, my lord, and going down my head, my lord, there is a judgment of the division bench when an institution or of this court, that when an institution or a state is going for a selection, it is not necessary to make all the selected
Not
candidates.
all the, even though representative capacity, you can make the last person who is selected in that category.
My lord,
Because there is all likelihood that if they are going to adjust you,
my lord.
then certainly.
They
has
could,
to
my
be
lord,
ousted.
as of, they have not stated how many posts were there, how many posts were there, what were the notified vacancies, nothing was there. They could adjust as it is a state, my lord. They could adjust me in some other place.
Okay. When it concept of the appellant is submitted that the private respondent herein is only one.
Only one.
The
Private
private
respondent.
respondent herein has not completed, has not passed the TET examination up to the age of, up to the, up to attaining the age of
38 years.
38,
Which was extended to 45 months.
extended to 45 when?
My lord, because in the first,
When?
my lord, in subsequent notification, they have deleted that.
It's fine. It's 38 years. And therefore, our candidature was rejected over later on after completion of the selection process pursuant to the advertisement. The government has issued a clarificatory note whereby the condition of passing of that examination before attaining the age of 38 years has been deleted. Stop. It is submitted that after issuance of the said clarification, the this private respondent has applied, has filed a writ petition before the learned single judge. After 7 months, the learned single judge has allowed the said writ petition, directing the appellants to consider the candidature of the
If your lordship permits,
respondent,
if your lordship will.
treating this,
My lord, if,
yeah.
because one post was lying vacant for me by an interim order. That post, my lord, as an interim order, court directed me to adjust there.
By treating the that qualification of the petitioner as valid, full stop. When the council has submitted that after the selection was over, all the vacancies have been filled in. And in the absence of making the selected candidates as party respondents, even in representative capacity, it would be difficult for the respondents to carry out it would be difficult for the respondents to carry out the directions given by this court. Stop. The net counsel appearing for the private respondent has submitted that there is no question of uprooting any selected candidates as this court, as the learned single judge by the interim order has directed the respondents to keep one post vacant. With it as it may, having heard the learned counsel of the parties here of the opinion that matter requires consideration, hence admit issue notice to admit Mr. Chaudhary put in appearance on behalf of the respondent number 1. Let notices be issued to the respondent number 2 to requisites be filed within a period of 1 week, 2 weeks. Notices to the respondents be made returnable after 4 weeks thereafter. 4 weeks thereafter, after 4 weeks thereafter. In the meantime, the direction given by the learned single judge to consider the candidature for the candidature of the private number 1 on the post of teacher. On the post of graduate teacher. Graduate teacher, is it?
Graduate.
Graduate teacher shall remain be kept in abeyance. However, the respondents are directed to keep the one post vacant if the same is still vacant pursuant to the direction given by this by the learned single judge.
I'm obliged.
Item 15.
But my lord will not be inclined to take up this matter.
Another bench.
Obliged.
Obliged.
Item 16.
Please, your lordship. Lordship, I'm seeking for 2 weeks of time to file the affidavit.
My lord, it's bail matter, my lordship. Bail matter, my lordship.
Bail matter.
Yes, my lordship. Tribunal, Armed Forces Tribunal, my lordship.
This petitioner is lodged here in which jail?
My lordship, Honorable Apex Court, my lordship, in Purushottam Das case, my lord.
Lodged in which jail? He is not at present, he is lodged where?
Info, my lordship. Imphal, my lordship.
Imphal.
Yes, madam.
Yes, the Honorable Supreme Court has held that against the order of the AFP, writ petition is maintainable. But
Yes, sir.
since he is lodged in Imphal,
Yes.
why don't you file this bail application before the High Court of Manipur?
My lordship, cause of action entirely is on Guwahati, my lordship. And my lordship, the genesis of the case started from the Taj Vivanta Hotel, my lordship. In Khanapada, my
That
lordship.
is in
And
relation to the incident where this court martial took place
court martial took place in Manipur, my lordship. But
in Manipur.
Manipur, my lordship, because
So this, no doubt, writ petition, this bail application may be maintainable. That we'll see. But first of all, why this, why we should entertain this petition here in High Court of Guwahati?
my lordship, tribunal, my lordship, honorable.
Tribunal may be for the 2, 3 states, tribunal may be here, but in fact, your case belongs to Manipur. That you have to address. On merit. Yes. Against the decision of the this court martial or I'm. Now, वो मैंने वो फिल्म देखा थी, because category where the victims on merit perspective, there is no for dispose of non maintenance and these are not the method that Ma'am, you have earlier also you sought time for filing reply?
Lordship, we received the parawise comments yesterday, so that is the.
How much time?
2 weeks time, Lordship.
Not 2 weeks. We are fixing it on 27th of March.
Lordship, 27th, my senior will be out of station.
Whatever it may be, you filed your reply, it's otherwise it's a case of sentence suspension.
Lordship, 22nd of March, it can be fixed.
22nd of March.
Lordship.
22nd of- Twenty-eighth,
Lordship, 28th,
make your own arrangement. This person can't be remain behind bars. After all, what is, and what reply you want to file? What reply? Have you seen that order of the Armed Forces Tribunal? The application has been filed for suspension of remaining inter alia on the ground that the trial was barred by limitation, electronic seized was so and so, payment bank account was so and so. However, counsel for the applicant has not been able to convince this court on these points and therefore bail granted, bail rejected. How can it? And counsel. You are for the Mr. B. Chakraborty.
I'm Lordship for the SK Medhi.
Hmm?
SK Medhi.
Who is Mr. Mehdi is appearing for whom?
For respondent, all respondent, Lordship.
All respondents, likhiye. And so and Miss so and so. For Mr. SK Mehdi pays some more time to file reply to the to counter to the writ petition. Full stop. Please notice that earlier also time was granted. However, in the interest of justice, last opportunity is granted to file the counter. List this petition on 28th of March. Not 28th March.
Highly obliged.
No further adjournment.
Item 17.
May I please tell us? My lord,
Give me, what is that counsel? Call. And the counsel for the, please come. We are fixing on, we are fixing this matter on 3rd of April.
yes, madam.
3rd of April.
Highly obliged.
We have fixed the next date is 3rd of April.
3rd of April. Okay,
Ask your senior to remain present or make a alternate arrangement.
Lordship. Highly obliged.
Item 17.
My lord, may I please tell us? My lord, in this case, my lord, annexure. My lord, annexure 3 is annexed, but it is not mentioned in the, it is missed in the petition, my lord.
What is this annexure 3?
Annexure 3, my lord, it is not, it is missed in the petition, my lord, to annexment.
Annexure 3 is the gazette notification.
Yes, my lord.
What to do with this gazette notification?
Gazette notification, my lord, here the, my lord, The case is that, my lord, in the Maizgram area, which is situated in the suburban area of Karimganj town, where in the nearby area, my lord, the engineering college, the human dwellers is there, but the massive cutting of lands by the land mafias, villas, my
Who are the land mafias?
I cannot say land mafia, but
Cannot say, then it's very vague petition.
yes,
Total 80% of the semi-hilly lands are belong to LM category, allotted to the landed person, but some vested interest person who are allotted selling these tillas to outsiders by way of an agreement for silly gain, and agreement holders are cutting the tillas and felling tree for the commercial purposes. This can't be a PIL. PIL, what is the research? You have simply said some persons are doing it. What is the material before us to consider and issue a notice for that?
my lord, this is the
This
violation.
can't be the nature of PIL.
In fact,
Come with the details and everything. Who are those persons? The persons are selling their lands. Is there any bar in selling the land? Pattas?
But there is no, but the sale is not by a sale deed, my lord. Just by an
Whatever it
agreement.
may be, that is, if the sale is not by the sale deed, the other party will not get any right over it. He will not acquire any title.
Your client has filed a writ petition on the same.
Yes, my lord, earlier.
And then he withdrew it.
Yes, that information I was suggested to file PIL, my lord.
it was not.
Suggested, the court has
Because
no,
the,
court has no business to suggest any person can do this. It is for the advocate.
this is right, my lord.
But it was dismissed without liberty.
And in this case, my lord, if this case is,
Want
my
to
lord,
withdraw this petition, then
to file PIL, my lord.
where is that? Do you have that order?
And lordship, nothing about that writ petition has been mentioned in the PIL.
Nowhere it is mentioned.
Nowhere, lord.
So, my lord,
It's a good case for imposing heavy costs. First of all, no such details, only bald allegations, vague allegations. And again, this suppression of material fact. That you have filed a petition which was withdrawn without seeking any liberty. How the second petition is maintainable?
my lord, at that, in the my lord, argument before the court, it was, my lord, asked that the PIL should be maintainable. You go before the PIL.
Where is
In
that?
this way, my lord, I have withdrawn this.
Is there any suggestion in this order?
Not suggestion, written suggestion.
Then, if you have not sought any liberty, certainly second petition, even in the nature of PIL, is not maintainable. Okay. This petition. This PIL petition is filed by the petitioner with a prayer to issue a writ of mandamus directing the respondent to stop further cutting of red soil / semi-hilly lands in the village. Majigram of Karimganj district. Full stop. Having perused the contents of the petition, we are of the view that the petition is filed without proper research and only vague allegations have been leveled without substantiating the same with any documentary or other evidence. Full stop. Learned counsel for the respondent. Yes, respondent number?
Forest Department.
The counsel for the forest department has submitted that earlier the petitioner has preferred WPC number 6712/2023 before a single bench seeking same reliefs. However, the said petition came to be, the said petition was dismissed as withdrawn while order dated 12/12/2023 without seeking any liberty to file fresh petition. Full stop. It is also submitted that the effect of filing of earlier writ petition has not been mentioned by the petitioner in this writ petition. Full stop. Taking into consideration the above facts, particularly the fact that bald allegations have been leveled by the, that vague allegations have been leveled by the petitioner in this writ petition without substantiating them with evidence and proof, and the earlier writ petition filed by the petitioner before the single judge was withdrawn without seeking any liberty. We don't find any, we are of the view that this writ petition is not maintainable. Full stop. It is very serious that the petitioner has suppressed the fact of filing earlier writ petition. And therefore, we deem it appropriate to direct therefore, we deem it appropriate to dismiss this writ petition with a cost of.
My lord, cost may not be enforced, my lord.
Why?
That,
Why?
in this case, my lord, I have filed a representation earlier, my lord.
Whatever it may be, why you have suppressed this fact before this court?
My-
Why you have suppressed?
I have not suppressed intentionally, my lord.
Okay, you are not suppressed, means you have stated that I have earlier filed a writ petition which was dismissed as withdrawn. Have you mentioned even a whisper about it?
During conversation, it was that, that your issue is reason maybe on PIL. So, my lord, that was withdrawn.
No, why? To withdrawn, then you should have sought a liberty.
Perhaps, my lord,
Supreme Court is very clear that if you have withdrawn a petition without seeking any liberty, can't maintain second petition. And even though if you feel that this petition before the single judge was not maintainable and before the division bench as a PIL it is maintainable, who prevented you to mention this fact in the memo of writ petition?
Same concept.
perhaps, my lord, missed unintentionally, my lord.
With the cost of rupees, yes, you
Well-
suggest or otherwise will impose.
My lord, that was totally unintentional, my lord.
No, unintentionally, that is not. You have to curb this type of petitions here, not here.
500, my lord.
What?
500. The petition,
Well, please try to understand it's a high court. 500,
right, my lord.
5,000 with the cost of rupees 5,000 to be deposited. To be deposited in the Guwahati High Court Legal Services Authority within a period of
3 months, my lord.
5,000 rupees, 3 months. Okay, pay the interest of 3 months also that. Within a period of 1 month.
Public.
Mr. Chaudhary, this is a serious misconduct. You are the counsel before the Lanet Single Judge.
Yes, my lord.
This is a good case to initiate proceedings by the Bar Council.
Public.
Consider yourself lucky.
Item 18.
Here, Lordship, I am for the response number 1 to 5, Lordship. We have filed our affidavit in opposition, Lordship, 1 to 5.
My lord, there are 13 respondents, my lord. 1 and 3 has filed their reply, affidavit in opposition, my lord. Others are yet to file their reply, my lord. If they do not file, my lord, I will file my reply, my lord.
You will file?
My lord, my reply, my lord.
Counter.
Yes, my lord.
Counter to the reply.
My lord, they have filed, my lord, this is a writ petition, they have filed an affidavit in opposition, my lord.
So what do you want?
My lord, I'll file a reply, my lord.
At the request of the council for that. Petitioner, 3 weeks, 4 weeks.
Item 19.
My lord, in the last order dated 7/2/24, they are to file an evidence enclosing the inquiry.
This, in relation to this incident,
My lord,
in relation to this incident of a person in police custody,
my lord,
namely Shafiqul Rahman,
and Asikul,
Shafiqul Rahman.
yes, my lord, yes, my lord.
This is the third petition here.
Lordship, I was about to
This
say.
is the third petition here.
My lord, we don't know, my lord, any other petition is pending, but
Is,
we,
this deceased wife has also filed a petition. Some other petition is also there in relation to this incident. Already some orders are passed. Inquiry was conducted. Some houses were destroyed. For that compensation was
Yes.
also ordered to be paid. What is this?
my lord,
Of this
so, my
one
lord,
incident, how many writ petitions and who are you?
my lord,
By the way, who is the
my
petitioner?
lord, I have given a detailed statement about the persons, my lord, the petitioners, my lord, at paragraph 5.
Paragraph 5.
Paragraph 5, my lord.
Yes.
The petitioner number 1 is a retired associate professor of Nagaon Girls College.
So what business he has when his the deceased wife has already approached this court?
My
What
lord,
business he has?
My lord, if there is some other case and there has been other order, this matter may be closed in the similar direction. And in this case, my lord, there was a order for inquiry. And there to,
We just want to. What is your locus in this matter, sir?
my lord, we are the, my lord,
Retired MA, petitioner number 1, MA, LLB, PhD and retired associate professor, Nagaon Girls College.
my lord,
Former professor and HOD of English, Assam, Downtown University.
my
He
lord.
was a journalist 2 times recipient of ML Kar Barua
My
Award
lord, his
for rural
writings,
reporting. He is author of book so and so.
my lord, learned person, my lord, of Assam, my lord.
History and crossroad, number of articles published in magazines. Biodata is very impressive. But how, what is the?
My lord, my lord, they are enlightened person of the district, my lord. They were, their conscience shocked, my lord, therefore they have approached.
Sadhu magazine, Gram Secretary, Chief Convener. Whether these petitioners are interested in contesting election or what?
No, my lord,
Then
no, my lord, no, my lord.
seems that.
They are
taking public
educationist, my lord. They are basically educationist, my lord. One is retired professor, associate professor, other is a retired principal, my lord.
How
It is
many
not
writ
true.
petitions they have in public interest they have filed till date? How many writ petitions in public interest they have filed till date?
My lord, so far my information, my lord, on the basis of an application of the petition number 1, there was another PIL, my lord. Somoto PIL in respect of the eviction on in the, my lord, Dholpur, my lord, in Dorang district, my lord. On his representation, my lord. So far my information, my lord. So, Mr. Sigdar, have the petitioners met the family member of the deceased? My lord. Have they inquired what are their difficulties, what relief they are seeking? Your clients, have they met the wife of the deceased before filing this writ petition? My lord, they have visited the. Where is the statement? My lord. Para 9, my lord. Page 15. The petitioner most respectfully beg to state that they have recently paid visit to the victim's family and they heard the members of the victim's family and elderly persons of the society were found in trauma, being terrorized by the action of this police and administration. They have produced some documents, including land documents, showing that their lands are patta land and covered by Miadi patta number so-and-so, in the said patta so-and-so, parcels by Iman Ali and purchased by Josna Begum, wife of Mujibur Rahman, through power of attorney. The delegation of occupying government land enclosed by the accused victims' family is absolutely incorrect. The eviction carried out by the same police force who have subsequently made search in alleged recovery of the crystal drugs. Moreover, the eviction was carried out on so-and-so, and when verification survey of land were conducted is an unbelievable story. The issue of custodial death of Safiqul Islam and encounter killing of Asikul Islam and illegal demolition of houses, Safiqul Islam, Iman Ali, Mujibur Rahman, Inamul Haq, Habizur.
Right, so where is the statement that the victim's family is not in a position to seek justice?
My lord. My lord. Yes, my lord. My lord, in the second paragraph of page 16, my lord. My lord, in the middle portion. All these acts of the police have terrorized the villagers, including the victim families.
Where is the other petitions, details of the other petition?
Lordship, there's another PI suo motu being taken up and it's fixed on 4th Lordship. In that PI Lordship, the inquiry report was already produced before your Lordships.
Which is, what is the number of that PIL?
Lordship PI suo motu 3 of 2022 Lordship. And it's fixed on 4th of April Lordship.
The wife of
Any other petition by the wife of this deceased?
Lordship, that information I don't have right now, Lordship. Lordship, I know regarding this PI.
Why the system of wife? What is the name of the wife of the deceased?
My lord, wife of the deceased, my lord. I've mentioned the
Custodial death.
wives of
Custodial death. 100 में नगद आहे सर. Grade 17 back, I think.
Okay. This public interest, this petition is filed on, by the petitioners in the design of public interest petition, highlighting custodial death of one Safiqul Islam on 21st of May 2022 and Asikul Islam in a alleged encounter on 30th of May 2022. Full stop. It is stated in the petition that after the custodial death of Safiqul Islam, the villagers are being threatened and assaulted by the police, and their houses have also been destroyed. Full stop. Have been demolished, has been demolished. Full stop. It is noticed that in relation to the very same incident, this court has already taken cognizance and has registered a suo motu PIL number 3/22, wherein certain directions have also been issued, including have been issued, and one member inquiry report is also taken, was also taken into consideration. Full stop. We are of the view that in relation to the same incident when a suo motu PIL is already registered before this court. No further on, before this court and wherein necessary directions, wherein certain directions are issued and the same is still pending consideration. We are of the view that no further order is required to pass in this PIL petition, the same is therefore disposed of.
Leave lovely.
Item 20.
May I, the Lord? Lordship, in this case, Lordship, the as per the order dated 5/2/24, Lordship, the respondent is asked to for Lordship is the instruction whether the post of principal in the said school was created or sanctioned.
Post of principal of?
Principal of in the said school was sanctioned or created, Lordship. Because
The post of principal was?
not created as per the appellate, no, Lordship. And the instruction was sought for whether the post of principal has been sanctioned or and created, Lordship, in the said school, Lordship. As per order dated 5/2/24, Lordship.
The late single judge has rejected your claim for appointment on the post of principal on the ground that you are not having qualification.
Lordship, the case of the appellant is that, Lordship, he is not for claiming for principal. Lordship, she is saying that, Lordship, she is claiming for, Lordship, claiming for headmaster, and she is Lordship, qualified for the post of headmaster. What happened, Lordship, in this case, Lordship, the school was a high school, Lordship, and it was upgraded as higher secondary as per the order, Lordship, page 56, Lordship. This upgradation is, Lordship, conditional upgradation, Lordship, and there is a condition there, Lordship. Lordship, page 56, Lordship.
That is not the single judge result that you were not having qualification for being appointed for appointment on the post of headmaster. Headmistress or whatever it may be.
No, Lordship, Larner Singular has said that I am not entitled for the post of principal, Lordship. Principal as per the rule, Lordship, rule 12 of the Assam Secondary Education, Lordship, provincial education rule, Lordship. And for the post of, Lordship, headmaster, Lordship, rule 14 is applicable, Lordship, 14(2), Lord.
This is.
What is the, where is the improved order 15/10/2022?
Lordship, the
Page?
Page, Lordship, 77, Lordship. Lordship, there is, Lordship, the petitioner, Lordship, page 56, 76, Lordship, kindly peruse, Lordship, whereby
Consequent
the
upon the retirement of the headmaster.
whereby the petitioner was allowed to hold the post, Lordship. Then page 77 is the impugned order, Lordship. By this order, Lordship, the earlier order was recalled, Lordship. On the pretext that the
degree diploma obtained from the different of in this particular matter, do not have the master degree and then she is holding the post of principal. So your earlier order was passed to work you as a officiating officer in charge of the principal,
Headmaster.
principal.
in charge headmaster, Lordship, because the sanction code is headmaster till now the post is headmaster, Lordship. The post of principal has not been till created, Lordship. And page 56. 14 September 2021. Upgraded. Amalgamation. 14 September.
The post in the school was of principal or administration?
This school was originally a high school which consists of the post of headmaster. Once it was upgraded on 14th of July 2021 to this as a higher secondary school, now the relevant post has to be the principal of the school. The principal,
Nomenclature has changed.
my lord,
Nomenclature has changed or what?
my lord, for a high school, it's up to class 10, so therefore there is a headmaster. Once it is upgraded to a higher secondary school, it comes up to class 12. Therefore, we have a principal there. And a headmaster is also there, vice principal is there, assistant headmaster is there. Now, on the upgradation, we upgraded the school, but we did not have a post of a principal created at that particular point of time. When the regular headmaster retired, she was allowed to hold the charge. Since this of headmaster, now when the school was upgraded, we needed a principal in charge because now it is upgraded. She does not have the qualifications of a principal. Therefore, we allowed the IS to hold the charge of the in-charge principal.
Who is having qualification?
But the inspector of school, my lord, is official. The inspector of school is there. So now she claims that since there is no post of principal created as such, she should be allowed to head the school as the in-charge headmaster. That is her case now.
Lordship, the person who was now allowed to hold the post of in-charge principal, Lordship. Lordship, I have filed an additional affidavit. Lordship, here, Lordship, kindly see, Lordship, this
Whatever
person.
it may be,
Lord,
is it legally appointed or whatever it may be, what is your right to be continued on the post of this, to have the
headmaster.
headmaster, not principal?
No, Lordship. The post of principal is not yet created, Lord.
Whatever it may. Ultimately,
Lordship, because if the post is not created, Lordship, the equation of Lordship, as per the Lordship, Assam Fiscal Responsibility and Budget Management Act, Lordship, if the post is not created and sanctioned, Lordship, the authority cannot appoint anyone to this post, Lordship. So, Lordship, if there is no post of principal, Lordship, the equation of Lordship allowing the in-charge principal cannot be.
yes.
Lordship, if there is no post of principal, Lordship, the question of Lordship holding the in charge of principal cannot come.
But
Lordship.
it is a higher secondary school now.
Lordship, now it is highest, but the post is not still created, Lordship. My submission is that, Lordship, till creation of the post, Lordship, she may be allowed, Lordship, because, Lordship, it is till now, Lordship, this school is going in high school. I may be allowed to, Lordship, I have filed an additional affidavit, Lordship. Here I have annexed, Lordship, the bills of this school, Lordship. Salary bill, Lordship. Purchase service paid, Lordship, 90, Lordship. In additional affidavit, Lordship. Here, Lordship, the person who is allowed to act as principal, Lordship. He himself had his, Lordship, designation is mentioned as headmaster in charge, Lordship. If it is principal, Lordship, it may be mentioned as principal in charge.
The petitioner, the applicant has filed this petition, being agreed with the order dated 18/11/2022, passed by the single judge, whereby the writ petition filed by the petitioner has been dismissed. Stop. The petitioner was earlier allowed to hold the charge of headmistress of the school concerned. However, later on, when the school was upgraded to higher secondary level, higher secondary level,
In the year 2020.
the order of allowing the petitioner to work as in charge headmistress has been withdrawn on the ground that a higher secondary school is supposed to be supervised by the principal, whereas the appellant is not having the qualification, is not possessing the qualification required for appointment as principal. Full stop. The net counsel for the appellant frankly admitted that though the petitioner, though the appellant is not having the qualification required for the post of principal, but at present, no post of principal has been sanctioned by the state in the school concern, and therefore she has a right to remain. She has a right to remain work as in charge headmistress of the said school. Full stop. Having heard the learned concept of the parties, we are of the view that once the school is upgraded from secondary level to higher secondary level, it is to be supervised by the principal only. And if the appellant is not having the is not possessing the requisite qualification for appointment for the post of principal, she cannot ask as a matter of right to remain work as headmistress in charge. Hence, we don't find any case for interference. The rate of appeal is dismissed.
Publication.
But allowing her to work as a in charge headmistress, we are recalled, and the inspector is allowed to work as प्रिंसिपल इंचार्ज। ये एक बाद में ऐड कर देना है, बता वो जो वहाँ पे शुरू में है।
Item 21 and 22.
Please, sir, my lord, sir, I beg to, for 2 weeks time to file our affidavit in reply, my lord.
2 months.
2 weeks time, my lord, sir, to file affidavit in reply.
But the request of land concept for the respondent list after 2 weeks.
Item 23 to 25.
Yeah.
My lord.
We have some, I have some personal difficulty to today after lunch. So.
Okay.
Any other date if you.
My lord, since it is an admission related matter, could it be on Monday, my lord?
Monday, this Monday.
Oh.
And Wednesday.
Wednesday will be.
On 20th, this time.
My lord,
Thursday.
let it be on
Thursday.
Thursday, 21st.
21st.
21st, my lord, I have some personal problem, my lord. I'll be in the state of Sikkim in another matter.
You can very well address the court through video conferencing.
My lord, from Sikkim, it might be a problem.
Sikkim,
Usually I prefer to appear physically, my lord. But today,
Mr.
today I had some personal problems.
Sikkim refile আমার কেটা side থাকবে না?
Sikkim, I think the network is good.
Yes.
That is.
My lord, I may try to do that, but will it be possible for your lordship to take it up on Tuesday, 19th?
19th may not be possible, sir, because we have already fixed certain matters.
I think 19, my learned friend also may have to go to Supreme Court because all these CA matters are fixed.
No, I am not in that matter. But this is a very simple matter. If your lordship, there is a letter from the department, my lord. My learned friend is also there. I will take 5 minutes, my lord.
You take 5 minutes, but we.
I will just take 5 minutes, my lord. There is a letter which will be placed by.
Just a minute, 1st of April. 1st of April.
My lord will then kindly fix it up on 7th of April, 8th of April, my lord. I will appear physically. I will come down, my lord.
7th of April.
Second. 7th.
I'm deeply obliged. 7th more is Sunday. 7th is Sunday. 8th April, my lord.
Eighth of it.
8th of
Monday.
So they are.
I'm deeply obliged.
Mr. Chaudhary, they are already, they have got provisional admission.
Only one, my lord, but subsequent years, the same problem is continuing, my lord. Yes, pursuant to one interim order of this honorable court, one student got the admission. My lord, matter is very simple. Now, my lord, within that category one, they're making the discrimination. In the earlier division bench judgment, Supreme Court, this honorable court says no. Against their SLP file, SLP dismissed, review file, review also dismissed. Now, how can they resort to the same thing, my lord?
We have proposed to amend the rule further.
You are
We have
seeking,
proposed to amend the rule
just a
further.
minute, just a minute, Mr. Mukerjan. But now you are seeking admission in the batch which has already been admitted and
No, my lord,
so 2 years have passed.
no, my lord, this matter is continuing from 2021. Every year we are facing the same problem. So lordship will have to decide the rule position clear. Then, my lord, everything will be in place.
My lord, we are going to
Basically,
amend the
we are
rule.
laying a challenge to the rule, validity of the rule. We challenged it, laid it once, which was upheld, went to Supreme Court dismissed. Same rule has been, my lord, they have brought in. That we have challenged again.
My lord, this particular rule, my lord, has been proposed to be amended further, my lord. And in the meantime, till the amendment takes place, the government has decided that the allotment of seats will be made under the state quota meant for the scheduled tribe local permanent residents, purely on merit basis, irrespective of category. The letter is there, my lord, with my learned additional advocate general.
We'll examine that aspect on the next date, yes.
Lordship, I'm deeply obliged.
8th of April.
Item 26.
May it please your lordship. My lord, before the other side proceeds, yesterday we have filed an affidavit. The issue was that we were debarred from appearing in the election because we have not attended 2 AGMs. My lord, through RTI, we have got the records where we have found many of the appellants has appeared in many of the AGMs in 17, 18, 16.
We asked them to produce the
Result, my lord.
See the result.
My lord, they were 15 posts were there, 14 were declared only eligible to be there. So there was no election. Directly they were
Eligible for what?
for the board of directors. My lord.
And you were declared.
Shareholders wanted to participate in the elections.
You have participated in it.
My lord, because my lord, the election was proceeded, we were stopped from participating because we are not.
This court's order was already there.
Order was there that the election should proceed. The result will not be declared.
Yes.
So there was no election. They were Dutch selection. Virtually, they were 15 posts were there, 14 were found eligible, and we have filed an affidavit, my lord.
So you have filed?
An affidavit yesterday stating therein that 124 was the notification where it was said for the last 5 years, 2 AGMs we have to attend. From now that they have filed an affidavit stating that from 21 there was Corona, 23 the board was dissolved, 1-man committee was there. So it was from 2016 the eligible period of 5 years will start.
Counsel. But the appellant has submitted that he has filed additional affidavit yesterday, placing on record some documents which received under the RTI.
My lord.
Stop. The copy of the affidavit is not available on record. Office is directed to place the same on record and this matter. When?
My lord, your lordship. 2nd of April, my lord, Tuesday.
2nd of April, month from Monday. 19th of April. 19th of April, till next date, the interim order passed by this court will remain in currency. The London Standing Council Cooperation Department, Cooperation Department is directed to is permitted to keep the result of the AGM election held on 8/2/2024 in sealed cover with the concerned officer only, which may be produced as and when directed.
Obliged.
You return to them and
I have the return.
keep it in safe custody.
For hearing, item 27.
My lord, Lordship will give, not today, will give some priority to this case, old matter.
What? Certain.
Then on 8th, Lordship.
My lord, it's a very small matter, my lord. I'll argue only on the scope of that proviso. Whether the proviso can take away the benefit which the substantive provision seeks to give. That's the only point. I'll just rely on 2-3 judgment. It can be taken up on Monday also, my lord.
Some difficulties, otherwise, so no problem.
I'll take only 15 minutes, my lord.
9th of April.
Let us fix it on the same day, my lord, on 8th.
So what is that?
Let it be kept on 8th.
Better 8th.
It's a matter of 1 week.
Okay, 8th of April.
Item
I'm
28.
deeply obliged. I'm deeply obliged, my lord.
There. Here, my lord, there is no urgency. Lordship can give it.
Thank you, sir. After the vacation.
Well,